morning. My name is David Thompson. I am a partner at the litigation department at STBB in Cape Town. My topic this morning that I want to chat to you guys about is quite an interesting topic, and really in the realm of a state agency, it has a lot of relevance. The topic that I want to chat to you guys about this morning is the Stipulatio Alteri. Now, don't get too worried about that. It's a fancy Latin word. It's a fancy Latin phrase. Basically what it means, it's a contract for the benefit of a third party. Now, why is that so relevant in the context of estate agencies? Well, I'm sure you'll agree that in the sense of an estate agency, one of your biggest assets or one of the biggest lifelines of an estate agency is the commission that you earn. Now, one of the ways, the predominant way in which you can earn commission is obviously to conclude a mandate, to introduce a willing buyer with a willing seller. You introduce the two parties, they conclude a deal, and you should in essence get your commission from that. But how do you, as an estate agent, draw yourself into that agreement? Because essentially what happens is an offer to purchase, in the majority of the cases, is really an agreement between the buyer and the seller. So how do you, as an agent, become a party to that agreement? And that is why the Stipulatio Alteri is such an important concept of our law. Because what it basically means is that the buyer and the seller, by contracting, can allow you, as the estate agent, to come into the contract. But what you need to do in order to become a party to that agreement is you have to accept the benefits of that agreement. And as simple as that might seem, you'd be astounded to see how many times that this actually doesn't happen. A lot of times we'd at STBB, we'd get a contract, obviously between the buyer and the seller. You'd go through the contract only to find that at the end of the contract, the agent in question hasn't accepted the benefits of the agreement. So what that means is that the agent hasn't become a party to that agreement. Now, where does that leave you as the agent? If the parties dispute perhaps the fact that you're not entitled to your commission, well, it leaves the agent in a very precarious position. Generally speaking, guys, very, very generally speaking, of course, there are always exceptions to the rule, but generally speaking, if you as an estate agent do not accept the benefits of that contract, you are not entitled, or you can't lay claim legally to your commission that flows from that particular contract. As simple as it might sound, it doesn't happen often, and we find that people, or agents in particular, get themselves into very, very precarious positions by not doing that. So as simple as it might sound, guys, please always remember, accept the benefits of the agreement. Now, I mentioned that there are always exceptions to the rule. So the question can come up, what will happen if you don't accept the benefits of this agreement? So say, for example, you've processed this transaction, you've introduced a willing buyer and a willing seller to each other, the deal has come through to STBB, STBB have done all the processing, and we're pretty much ready to go. Now all of a sudden it comes time to pay your commission, and oops, guys, we find out you haven't accepted the benefits of that agreement. Where does that leave you? Well, if the parties are reasonable and if they're nice, they will allow that commission to go through with no issue. The problem comes in is that if one of the parties starts disputing your claim to your commission, now what do? There's two cases that I want to refer you guys to, which perhaps give us some guidance on how these things are dealt with in practice, and also highlights the importance of accepting the benefits and what could also happen if you don't and if you do. Two very interesting scenarios with different consequences, with different sets of facts. I'm just going to refer to my notes quickly so you guys have the correct reference of these cases. The first case that I'm going to refer you guys to is Foster, NO, versus PM Security and Crime Prevention, Pty Ltd. It is an appeal decision of the Gauteng Provincial Division. It is a 2015 decision. The next case that I'm going to be dealing with in comparison is called PG Share Dealing, Pty Ltd, versus First Realty Randburg, Pty Ltd. Also an appeal decision from the Gauteng Provincial Division as well. So these are the two cases that I'm going to contrast with you guys today. The first decision in the Foster case, what happened was it was a normal OTP, buyer and seller, wasn't suspensive on anything. It came to a point where there was a dispute about the commission that needed to be paid, and the agent actually tried to sue for their commission. And what happened is that one of the parties to the sale actually raised the defense that the agent had not accepted the benefits of the commission flowing from that agreement. That was a defense that was raised in that case. And basically how the court dealt with that in basic terms. So I've given you the general position. So generally speaking, what would happen is that the agent wouldn't have been entitled to their commission. But what the court did in that particular case, they took a purposive view and a holistic view of how this transaction transpired. They looked at all the surrounding circumstances of this case, and they said, well, if you look at everything that's happened in this case, all the surrounding circumstances, there's a couple of things that really point towards the fact that the agent, it can only be that the agent obviously accepted the benefits of this agreement. The court held in those situations that the agent was entitled to their commission. Now, that was specifically dealing with a situation where an agent hadn't accepted the benefits of an agreement. The defense was raised that they weren't entitled to their commission because of their failure to do so, and where the court took a holistic view of the case and said all the factors point towards the fact that despite the absence of the signature, the agent had accepted the benefits of the agreement, and they were then entitled to claim their commission. So very interesting, a slight shift from the general rule, in a sense of the general rule being if you don't accept, you can't claim. Now there's the shift to say, well, they haven't accepted, but let's look at all the circumstances surrounding the case. So just keep that in the back of your mind for one moment while I move on to the next case. In the PG share dealing case, also normal, buyer and seller conclude an offer to purchase, except this agreement was suspensive. And by suspensive, it meant that the agreement as a whole, the enforceability of the agreement as a whole, was suspensive upon the purchaser obtaining a bond, obviously to pay for the purchase price. So what happened was, and then guys, just also remember, in terms of the bond clause that you normally find in your OTPs, there's 9 out of 10 times, probably 10 out of 10 times, but 9 out of 10 times just to be safe. I always stand to be corrected. The bond clause will have a time limit of when the purchaser is allowed to, or when the purchaser should obtain a bond in order for this deal to go through, because obviously you can't have it lying open in perpetuity. So you have to have a time limit on when the purchaser will be able to obtain their bond, and if they don't obtain their bond within that time limit, then because it was subject to, the whole agreement falls away, because you can't perfect the agreement, right? So in this particular case, that was the scenario. A and B enter into a contract, B being the purchaser, and obviously having a subject to clause. Throughout the transaction, the purchaser did obtain their bond, but outside the time limit. So let's, for argument's sake, say that the purchaser was supposed to obtain a bond within 10 days, right? On the 12th day, for argument's sake, the bond was approved, but this was after the 10 days. So the parties then agreed that this agreement would be cancelled and they'd walk away. The agent then instituted a claim for their commission on the basis that the contract had actually been perfected, that because the bond had been granted, that it was no longer suspensive, but the sticking point was because the bond was granted after the 10-day, for example, time period. But what is so important about this case, and why it's so relevant to the topic of a stipulatio, is because in this particular case, the agent actually accepted the benefits of the agreement. So there was a clear and unequivocal acceptance of the benefits that flowed from the agreement. And quite interestingly, and something that perhaps agents don't necessarily realize, is that there is more than one kind of benefit that flow from an agreement if you accept the benefits. And in this particular bond clause, it said that the bond was supposed to be granted within the, for example, 10-day period, but that period could be extended at the sole discretion of the agent, right? So the agent's argument was that because they had their sole discretion to extend the period when the purchaser could obtain the bond, because the purchaser obtained their bond, for argument's sake, say on the 11th or 12th day, the agent then said, well, I've extended the period by a further 10 days, meaning that the acceptance fell within the extended period, meaning that the agreement was actually perfected and the agent was entitled to claim their commission. So, guys, what's very important here is to look at the contrast between these two cases and to look at how the courts have treated these two cases in the realm of the stipulatio and accepting the benefits of an agreement. So in one instance, in the Foster case, there was no clear and unequivocal acceptance by way of a signature, but the court looked at all the holistic circumstances surrounding the case and said, oh, well, you know, because of all the facts, it points towards an acceptance, so therefore there's an acceptance. But quite interestingly, in the PG share dealing case, I think that if the agent hadn't expressly accepted the benefits of that agreement, thereby enabling the agent to extend that bond clause period, I don't think that agreement would have been upheld. And I don't think that the agent would have been entitled to their commission. So it's very interesting to see the two contrasts. So in one instance, they were saying, well, it's not that important that they haven't physically signed, look at all the circumstances. But in the other case, they really put focus on the fact that because of the stipulatio, and because the agent actually accepted those benefits, they were entitled to do this. So, guys, the moral of the story is, where does it leave you as an agent insofar as accepting the benefits of an offer to purchase? I wouldn't risk it. The case law is a little bit split on how they would deal with an instance where an agent doesn't expressly accept the benefits of an agreement. So, guys, best practice, advice from STBB, always please accept the benefits of your contract. If you don't accept the benefits of the contract, it's not to say that you're not going to be entitled to your commission as a flat-out general rule, even though I said generally speaking. But it's not to say that that is the absolute rule. As we've seen in these two cases, the courts can treat circumstances differently. But the problem with not accepting the benefits of an agreement, guys, is that you as the estate agent are going to have the burden to prove that you accepted the benefits of the agreement. In closing, I just want to say, please keep your best practices going, accept the benefits of the agreement, and make sure that we do business properly and that we keep our wits about us when we're entering into these agreements, because we don't want to end up in litigation, I can promise you. So guys, for more information on anything that I've spoken about today, please follow us at STBB. Please go to our website, stbb.co.za. And guys, thanks a lot for listening to me. I hope to see you again soon. Cheers.